And we want to interrogate that story. Yesterday, former Prime Minister Raila Odinga petitioned the Supreme Court challenging the election and also the victory of Deputy President William Ruto, who was elected the 50th President of the Republic of Kenya, and of course declared by the IEBC. Now, before actually we'll have a discussion on what this petition is about and what impact does it have to the politics of Kenya, but also to the entire East African community, by the different lawyers and of course different experts in that direction. Now, before we do that, joining me in studio first of all is Vivian Kamsime. We just want to give you a preamble of what exactly happened yesterday before we engage senior experts and lawyers to actually break it down for us. What does this petition mean, and whether actually the prayers by Raila Odinga are achievable from the Supreme Court? Vivian, that's a very pertinent question. Raila's prayers are achievable? But actually, before we do that, first take us through of what are the grounds that actually Raila is raising and what are his prayers for that matter?
Of course, yesterday, Raila Odinga was at the Supreme Court filing a petition, a 72-page document with his running mate, Martha Karua. They came in with a truck full of evidence. And of course, we know that the petitioners there are him, Raila Odinga, Martha Karua, and then the respondents who are IEBC, Chairman Chebukati, the persons of Chairman Chebukati, and the other commissioners, the 6 other commissioners, plus William Ruto there. Some of the major grounds that were in the petition were that Odinga was alleging that Chairman Chebukati did not have the right to announce a result without the backing of the other commissioners. Also, he argues that the voter turnout figure was manipulated to ensure that Mr. Ruto crossed the 50% plus 1 vote threshold to avoid a second round runoff.
Yes.
Also, he says that the Electoral Commission did not act in accordance with the Constitution and the Elections Act of Kenya. And as such, he has 3 major prayers before the court. And Odinga wants the election nullified so that there can be another election that is organized by a different leadership at the IEBC. That is actually the second prayer that he wants to put up to the court, that he actually put out to the Supreme Court. Odinga also wants a forensic audit on the chemist kits that were used by the IEBC. He wants the IEBC portal to be opened up and checked. He also wants the presidential election forms, including forms 34A, 34B, and 34C, done, scrutinized, and checked out what exactly happened there. So
actually, we understand that there are many, other petitioners who were actually part of the group that petitioned the Supreme Court. Who are these petitioners and what are they seeking to achieve?
There are a number of other petitioners that brought individual petitions. There is one agency, an NGO. There is also Chigame. Chigame was a person who wanted to run for the election as an independent, but was actually denied by the chairperson or the IEBC that said they did not have the other signatures from the voters. So he has teamed up with a group of others to actually petition the court on this election. Also, the other one, which has been very sounding, is that of Moses Kuria, who actually is accusing Odinga of having masterminded the chaos at Bomas that we saw the day the chairperson announced President-elect William Ruto. He wants to deny him a chance to be heard, that he's not deemed fit to actually benefit from whatever court would actually be ruling, because he was the entire brain behind that Bomas chaos. There are also other, of course, petitioners that suing Ruto himself, and of course the other IEBC. Out of all this, the chairperson, Chairman Chebukati, and the IEBC are the ones who have been most sued.
They are the ones who have been most sued, and of course we will actually have a much more discussion on what exactly is going to take place in the courts and how actually this petition can as well be granted, either granted by court or be dismissed. We will actually be joined by different lawyers, but before we do that, to actually have a highlight of what is taking place, the Supreme Court of Kenya is actually in the hot spot. It is actually there to determine this case, whether actually William Ruto was declared rightly as the president of Kenya, or it was actually otherwise. Now actually want to take a look at the judges that are sitting at the Supreme Court and what this exactly means to the Kenya. Now this Supreme Court is headed by the Chief Justice of that country, and of course we all understand that what exactly all Supreme Courts most of the times are led by the different Chief Justices of the country, but of course we just want to first look at that before actually we have a further discussion of what exactly and what lawyers think how this petition is going to go like. One of the most interesting questions that actually I want us to look at before we even engage the different lawyers about this matter is the fact that this petition is, I don't know how it's going to be handled, because like there are 9 petitions, you know, all seeking to get different results. How do you think this is going to be handled?
These petitioners are not seeking different results. Of course, the major prayers that they are seeking from court are basically nullification of results, a vote recount, or a rerun of, or a forensic audit of the entire system.
Yes.
And of course, what the court normally does is to merge these cases.
Okay.
And if your case cannot be merged, then it could actually turn out as evidence or witness or something in the election.
That's one also of the issues that actually
petition.
we're going to ask the lawyers to actually clarify on.
Yes,
but also one of the interesting issues also in that petition is that one of the about 4 of the respondents are actually dissented from the results and never signed the results that were announced by Chebukati.
Yes, the 4 commissioners, they've been part of that process. And that's what I was talking about, Mubarak, that they have been part of the process right from the word go. And even at the very last minute, we saw them announcing results on live TV. What happened at the end?
Thank you so much, Vivian. And also, actually, we'll come back to you later in the show to tell us why William Ruto actually is also part of the respondents. And also, the lawyers will be able to clarify on that. We are just going to take a breather just briefly. We are having actually 2 lawyers, Dr. Daniel Ruhweza, a law don at Makerere University, and also Counsel Edgar Tawaro, a lawyer at KTA Advocates. We're just taking a breather. We are actually returning with much more analysis. Are Raila's prayers achievable? The lawyers will tell you what actually entails that.
Although polling day in Kenya was peaceful, the announcement of the results a week ago sparked angry protests in some Odinga strongholds. There are fears that a drawn-out dispute may lead to violence in a country with a history of post-poll unrest. Since 2002, every presidential election in Kenya has triggered a dispute, with this year's outcome also causing a rift within the Independent Electoral and Boundaries Commission, which oversaw the poll.
7,176,141.
Raila Odinga, who was making his 5th bid for the top job, also approached the Supreme Court in August 2017 when President Uhuru Kenyatta was declared the winner of the presidential race. The court annulled that election in a first for Africa and ordered a rerun, which was boycotted by Odinga. Dozens of people died during a police crackdown on the protests. Judges now have 14 days to issue a ruling. If they order an annulment, a new vote must be held within 60 days. Hundreds of Odinga supporters gathered today, blowing whistles and waving placards reading, "Electoral justice now," and "We want justice now."
We don't support Ruto. We support Raila Odinga. They must do him justice. We mothers want him as our president. We voted for him in numbers. He is the president we chose.
Kenyans, we want Raila Amolo Odinga to be our president. We vote for election peacefully, but Chebukati has done a very wrong thing because Raila Amolo Odinga is the one who win the election.
Judges are also expected to consider other challenges against the result, with the court clerk telling reporters the tribunal had already received one petition filed by a voter. Odinga, who buried the hatchet with Kenyatta in 2018, winning the
Welcome
president's
back to
backing for
the
his
Rush Hour. My
candidacy,
name
said
is
last
Mubarak
week.
Mugabe. We are actually having the big issue and we want to interrogate what exactly took place yesterday in Kenya. Former Prime Minister Raila Odinga, also the second runner-up of the presidential elections in Kenya, petitioned the Supreme Court seeking to nullify the election of the Deputy President, William Ruto, who was elected as the 50th president of Kenya. Now we want to find out whether actually Raila's petition can as well, these prayers in the petition can as well be achievable. Joining me this morning to discuss all that are two distinguished lawyers. One is Dr. Daniel Ruhweza, a law don at Makerere University, and counsel Edgar Tavaro, a lawyer at KTA Advocates. Gentlemen, thank you so much for actually joining me this morning.
I actually used to be a law don as well.
I was just about to say that, that...
we
yes,
taught together.
Yes,
certainly,
yes.
actually.
I went for the softer things of life.
and you left him to supervise coursework. Let me start with actually you, counsel Edgar Tavaro. The petition is filed. What next?
The petitions are filed.
The petitions are filed, but actually I want to focus ourselves on Raila's petition. Yes.
Many others have no issue. I think what you're likely to have is a consolidation of all the petitions, because they all address the issue of nullifying, and certainly the facts must be arising from the same series of transactions. I've argued election petitions on behalf of the Electoral Commission, who are our clients for KT Advocates, but he's had the advantage of being amicus curiae in the last presidential.
He gave us that term, we didn't know what it meant.
On the last presidential petition, he was part of the...
Actually, not the last, the 2016.
No, 2021, was it?
2016.
Yeah.
Oh,
2021 was aborted.
It's already, yes,
7 years old.
absolutely. And there was another petition last time. Which
Which was aborted, withdrawn, yes.
Yes.
It didn't proceed to the level where they'll give us jurisprudence. And I'd like to set it up from the onset that in hotly contested elections like this, going to seek an arbitration or going to an arbiter who is ideally neutral and give his expert opinion or give their expert opinion is a reasonable thing to do. It enriches jurisprudence, it deepens democracy. The 2001 electoral petition of Uganda has been used as a precedent, even in the Republic of Kenya, to inform their processes. Although now I think we might have started using our process. So going to court, one, it's a face-saving measure. You know, you promised your electorate so much, and you've told everybody that the deep state is behind you, and this is your thing. You got to win it. So you go to the court to save face. Two, one, more importantly, after 7 days of waiting, anxiety grew.
Yes.
And because of that anxiety, anything could have happened. So going to court is another way of cooling the tempers, especially for the Republic of Kenya, where the politics are deeply ethnicized. Although on this occasion they've not been as ethnicized as the past, but you know there are those deep tensions, and given their background of political violence, grounded in ethnicity, it's very critical that you have this kind of thing. Three. What was the question again? You were saying?
What is next? We are saying the court is having the petition already. It's filed.
Yes.
What exactly now are we likely to see happening?
There are eight petitions. No, 12 petitions and 8 applications from interlocutory orders. Interlocutory orders are interim measures. The Ahmed Nasir, former president of the Law Society of Kenya, is a senior counsel, quite a maverick. Nicknamed the Gwandu Mola by Dr. William Mutunga. He's what would I say? I don't want to sound so insulting. He's a better version of Semakade. He's a better Semakade, meaning of Semakade is good, but this is a better version.
The views expressed on this station
of this station. Yes. So he tweeted and said that I think the strategy of Raila is to boggle down the courts.
Yes.
Well, we wait to see, and the petition is presented. The grounds have been presented by court, and the orders have been presented by court. And let us discuss that. But more importantly, I said it on this show. I've said it on other shows I've been appearing on, that we're going to have an interplay between quantum physics, robotics, and big data. Or simply put, the interaction between the physical world and the virtual world, artificial intelligence, and its relationship with the physical world. And one of the major contentions in this petition is that the physical tallying and the tallying that was the portal, the server that was released finally by Chebukati are what at variance.
What is actually, I want to bring in now Daniel, what is at stake now that the petition is filed, and what are we likely to see next?
Right, thank you, Mubarak. So we have, I think, two main issues at stake. First of all, it's a test on the courts. You know, we have the first female Chief Justice that is going to preside over this presidential petition. She comes, you know, with a background of the Moranga judgment, the BBI, you know, judgment. And so it's a test on her and on her court. How is she going to control the court? What type of decision is she going to make? We are going to have the opportunity now to see what type of leader she is of that bench. But even more importantly, what school of jurisprudence does she belong to? By that I mean, is she a literalist that you look at the law and only the wording of the law and interpret the law as is? Or is she the kind of judge, or is the panel the kind of panel that goes beyond just the wording of the law and starts asking what were the intentions of the makers of these laws? And so we'll also see whether in Kenya again we have moved 10 steps forward or 10 steps back, especially with the amendment that made it possible for Moranga, the Justice Moranga, to annul the election. So that is the first thing that I believe we are going to see. Secondly, I think it's a positive step, like Edgar has said, that we expected the whereas and wherefores of the lawyers to now come in, but we are going to see what kind of lawyers.
The showdown
between the legal minds regarding the whole interplay of what Edgar is talking about. Was the will of the people protected when it was expressed? And so we are expecting to see President-elect now Ruto, the Independent Electoral and Boundaries Commission, and others who have been brought in as respondents, being able to present their side of the story. But more critically, I am waiting to see how the IEBC commissioners are going to make that interesting response.
We're actually going to get to that issue, because we understand that some of the commissioners that are respondents are also dissented from IEBC chairperson.
Very interesting scenario.
But very interesting scenario. We'll get to that. I just want actually to pick your mind before I engage Edgar again. What exactly is going to take place? Now the petition is filed.
The petition has been filed.
Are we going to see now lawyers discussing, interfacing, or because we are seeing Edgar was talking about the other...
No, what we are going to see is going to be the filing by the respondents. The respondents have been given time to also file their response, their paperwork, and then I believe that we shall have some kind of scheduling conference to agree on what the timelines are. You know what are the timelines? They have a limited time to have this matter resolved.
That's within 14
days. Yes, within 14. That's just 2 weeks. So we'll see them file their responses. I think there will be a scheduling conference, and then we shall start hearing the applications and their responses.
Edgar, these are many petitions. How does actually this court can this court actually handle all these petitions in 14 days?
Yeah, at scheduling. Yeah. At scheduling, you narrow down the issues. Yeah. At the end of the day, I think the issues are going to be one.
Actually, for the benefit of our viewers, just say something about what we mean by scheduling.
Oh, scheduling is a pre-hearing conference where you narrow down. You narrow down the matters in controversy. What is agreed and what is in controversy and what the court has to resolve.
And therefore you find that maybe there will be 2, 3, 4 issues that are really in contention, which they will focus on. Yes.
At the end of the day, there will be similar things, and no, at that point, there are things that are agreed upon. So this evidence, this one, this, and this is what remains in contention. But again, I'm referring to Ahmed Nasir. He said, before we could even look at the petition, I think for him he had already perused, and said 90% of the petition is Chibukati. Yes. So apparently at the end of the day, it's going to be a test. Chibukati is in the dock.
Yes.
It's a trial of Chibukati because his own commissioners, who are respondents, disagreed with his final decision. So we are likely to see a situation where the commissioners swear affidavits, ideally in response, but in favor of the petition. And and I think one of the major issues.
Have we had these precedents before?
Yes, in the BBI case. The one that was
Building Bridges Initiative.
They were challenging the issue of the chairperson of the commission's powers were challenged, and I think it's going to be one of the major points to consider whether the decision of the chairman is the decision of the commission. And who has the final say? Who makes the final call on as to who becomes as to who is the elected one, as to who signs Section 34B. Actually, it's the chairman who signs and declares. That is Section 34B. Declaration is a certificate of declaration of a winner. Now, if the other commissioners disagreed, does that then disempower the chairperson of the commission? That's going to be a major contention.
And it's actually very good for us to even deepen that conversation. Ideally, there are roles and duties of the commissioners, but the commissioners cannot work just the 7 of them. They have a huge secretariat, a huge group of employees that support them, send them the results, and so on and so forth. So it will be interesting to see how the court finally decides on what the commissioners actually are supposed to do. If the commissioners are in disagreement either with the result or with the process with which it is being collated, what then happens? It will probably not be really, maybe the legal issue there would be regarding the powers that have been expressed in the law already. And I think there is somewhere in the law which talks about that on matters of an administrative nature, the commissioners must have some kind of consensus. So one of the bigger questions has been if they all don't agree with the results, in spite, and let's assume that the result that has been brought in by the team is the right result, is the properly collated result, and they don't agree, then what happens? I think that is
the benefit of hindsight. I think the late Samuel Kivitu has been vindicated. Because Kivitu said, look here, I don't know with exactitude who won this election, the one of 2007. I announced the results that had been given to me by the commission secretariat, which is the same thing Chibukati has done.
Actually, Edgar, I just want to, because you have defended the electoral commission before. What is the position? How do you see this electoral commission? Can it really defend itself from these kind of allegations and from these kinds of grounds that are raised.
There are no
by Raila.
allegations.
And-
They are statements of fact from members of the commission.
Yes.
No, I mean for the allegations from Raila, bearing in mind that actually his commissioners, the commission is totally divided. How easy is it to defend such a commission?
How is
From
it?
a lawyer's perspective.
Well, we'll have to go back to one, the spirit of the law, and this is where Dr. Ruweza was very clear. That's the point he was trying to build on. That are we going to have a bench that is going to breathe life into the law, or is going to look at the law as it is, the literal interpretation that says this and that is it? They'll have to go back to the Hansons.
Yes.
And see what
Yes.
was the intention of the legislature.
Yes.
In there's another another pertinent point that we need to consider. In administrative law, you look at the process.
Yes.
You question the process.
Yes.
And not the decision. Now, in this case, as it were, we are questioning both the decision and the process. You're saying that the process was marred by irregularities because the chairperson, the commission was not fully constituted in as far as reaching the final verdict is concerned. So, we both taught administrative law and administrative processes at university. And one of the key things in administrative law, when you're looking at processes, the issue of quorum is very important. And we've had decisions of administrative bodies overturned because of lack of what? Quorum.
Yeah.
Now, in this case, could you say they had quorum?
Or not?
Is the quorum about the sitting, or is it about the argument? So it's really...
Yeah. And I think somewhere around there we'll have a very interesting decision.
A precedent that is going to...
Because I saw the law establishing the commission, and by this we mean the one of Kenya. Yes. And the decision-making process. So we are asking, is it about, when you talk about administrative or the decisions that need quorum, can you make a decision when the results are saying something else? Can you contest the results? You know, that would be very interesting for me to see, as opposed to maybe decisions on budgeting, decisions on when shall we hold the election. You know, there is a difference. But in this case, you have the results are coming in. And I think the problem with the commissioners was in those last 7 days. You know, I think when I listened to them, they are talking about that last part when, maybe the last 3-4 days, something became opaque.
The process was very good.
Yes.
The last
So in other words, we are actually investigating the end of pipe process.
Yes.
The product, not...
Yes.
Not
everything else seems to have been fine.
Okay.
Yeah,
until
Odinga is raising a very interesting question of having commissioners swearing affidavits in favor of the petitioner. Does this actually make Raila's petition reach?
Maybe just to be clear, Edgar is not saying they will swear in favor of the petition, but he's just saying that they will probably swear affidavits that may help the petitioner. Yeah, because one of the arguments by the petitioner is that something happened in the process at the end, and it seems they do not agree with the final decision that was made. And that is why they are calling for a forensic audit, which is going to be quite interesting. And you know, and probably what our court here has always been asked to do, to jump into the fray and carry out an inquiry. Because when you order a forensic audit, you're basically saying, we trust somebody else to look at
this process,
the results, and collect them anew. Now, it will be very interesting to see whether the court will agree with that forensic audit, you know, or not. Yes. Who will be asked to do it? You know, will it be KPMG? Will it be PwC? That will now determine, you know,
is advertising for their services.
It will be very interesting to see. Yes.
Edgar, how much evidence And what standard of proof or evidence that actually Raila needs to present before court to have this petition granted?
In Kenya, the standard of proof actually shifts to the Electoral Commission. Once they've raised.
No, that's the burden.
That's the burden.
The burden. Oh,
I mean, you know, how much, how much, and what standard, certainly.
In election petitions, it's above the ordinary civil suits. You need to prove the proof, not necessarily to the level of criminal or penal, the penal code, but the standard of proof is higher than ordinary cases. So and that's where things like the forensic audit, the forensic tallying, or forensic, what do they call it, investigation in the tabulation, in the correlation of the data would be very critical.
Okay.
And courts
will determine.
First of all, it's a prayer that has been made, but also in situations like this, you invite experts to come and give their opinion.
Looking at actually these two
Yeah,
sides.
but you should also add that in the law of evidence, the court remains the expert of experts. So it will be very interesting to see if, for example, the court agrees with the petitioner and orders for a forensic tally, whether the court will also agree with the forensic tally. Yeah, because the court still need not be bound by that expert. To be very interesting.
We have
to
a
see.
situation that is before us. We've seen it elsewhere. We've seen it in the United States of America. I even dare say in the British Crown courts. The British courts, and particularly Britain, has a very peculiar practice of the law. The courts exercise their power for and on behalf of the Crown. In Kenya and the Republic of Uganda, it's Article 1 of the Constitution, all power belongs to the people,
Yes.
and the courts shall exercise their powers. The courts derive their power from the people, and they exercise it for and on behalf of the people. So we are likely, what is going to play out, to summarize it, is the politics of the law, and the law of politics, because it's purely a political question.
Yes.
Purely political
question.
Purely a political question.
So we expect a political judgment, certainly.
Let me put it this way, that the political lenses of the judges will
Well, just to add to what he has said, that Professor Joe Lokanyango wrote a book, probably his most recent book, When Courts Do Politics. And in there, you clearly see that you can divorce the politics from, Now, some judges may not agree with that position, I'm sure. And they say, no, we are as objective as possible in these circumstances. But, about elections, I remember in our first year class, Chief Justice then Benjamin Odoki said that the courts tend to maintain the status quo.
They are very
that's why the Maranga judgment remains like 1 in a million.
Malawi followed.
So you have like
two
or three that have
a presidential election.
Yes, a presidential election. So it's very rare. And so
just to let you know, we're in the same class.
At the university.
Justice
I just want actually to bring in Daniel here. You talked about the standard of proof and what is required. Now, who has actually the biggest burden? From a lawyer's perspective, I mean, who has the biggest burden? Is it actually the lawyers from the respondents or the lawyers from the petitioners?
My view is that, according to the Evidence Act of Uganda, which I'm sure has a similar in Kenya, and of course we have a background of common law, from England and so on. So the Evidence Act says, he who alleges must prove, So if you have alleged something, then you have to prove, so the burden is upon you to substantiate that allegation. So the petitioner does not have an easy task, They have to be able to show that the things they are alleging actually happened. And that is their burden. Now the standard is what Edgar has also said, that their standard is almost but not really at a criminal yeah. So they have that burden.
I was talking about
yes.
the, you know, that in Kenya actually the burden shifts to the Electoral Commission. How is that? How is that possible?
Actually,
and why should
the circumstances, it's even much more shocking because Chebukati is on trial. His own commissioners are putting in the dock. Yes. So as to whether or not Chebukati is the EC is another issue.
But nonetheless, that notwithstanding, we can't run away from the fact that the Raila, Odinga, and the other petitioners have to make their case. It is one thing to make an allegation. It's another thing to bring that allegation to life. You know, in the movie Law Abiding Citizen, there's something that Jamie Foxx says to the client. He says that it's not what you know, it is what you can prove in court. You know, so you might actually know that something went wrong, but can you be able to prove it? Because the court system is a unique environment, right? You might rely on the words of a witch doctor, and I'm not saying that they are witch doctors that informed this. You may rely on the word of a witch doctor, but in the eyes of the courtroom, you must be able to fulfill the standards that the courts want, you know. So that is why even in the Bible it says that sort out your issues with your adversary before they take you to court. Because outside the courtroom you have a good case until you appear before their lordships.
To the judges. I just want Edgar, we saw these petitioners, we saw a list. You're saying actually Chebukati. We're actually seeing all the list, but we are looking Chebukati in the dock. But surprisingly, people were shocked. I'm talking about lay people. What crime did Ruto commit to appear there as the last respondent?
Oh, yeah, because the orders sought, the orders and declarations that they are seeking largely touch on the election of Ruto. So he's not just, he's actually what they call a statutory party. That if you are seeking to nullify, you're questioning the EC, but you're also seeking to nullify an election of a president-elect, then that president-elect should be a party to the suit.
So what would be actually Ruto's role in this case?
Oh, he has to defend his seat, so to say. He has to defend his seat for the justice of the occasion. To achieve justice, you have to give the other party a hearing. And
he'll most likely have to bring you know, swear affidavits and say something to the effect.
He has already lined up a team of all senior counsel, all of them, Philip Morgan, who former DPP, team of senior counsel.
They have to defend the decision of Chebukati. They have to defend and say that the process produced the rightful winner, you know, and because if they don't do that, sometimes the assumption is that if you have not responded, then you are in agreement with the petition. But not guilty or whatever, it is more liable than guilt, because here it's a civil matter. So the reason he is there is because whatever order is going to be made affects him directly as president-elect. And so he has to defend that position, that he went through a rightful process. He believes that the result as collated, he will probably bring his own results if need be to show that even in our private tallying, the evidence from our, the people who, what are they called, the ones who witness the tallying, on behalf of their polling agents will probably say that
I can see you've not participated in the
elections. Say that they are the ones.
So actually,
what is critical, what I found particularly intriguing on this occasion is that the Railas agreed that Ruto beat them, but he didn't obtain the 50%.
That's right.
And you shall recall there's a show on which we appeared with Dr. Ruhweza that had Sarah Biret. She went there as a so-called
observer,
independent observer. And the tally they have seems to be agreed with Raila's, that Ruto probably obtained 49.6%, didn't get the 50 plus one required vote for. So in her opinion, she says there should be a rerun. Now, Raila is not requesting for a rerun.
Is requesting for a fresh election.
For is it a fresh election?
Yeah, fresh election, yes.
What
one of the grounds.
No, one of the grounds that will be declared the winner, which is.
I thought that's what he had asked, but maybe I need to revise.
No, actually,
it's one of what
he's talking about organizing a fresh election under a different chairman and a different chairperson. How possible is that?
I think there is nothing impossible under the sun. There is nothing impossible under the sun. But my experience has been that courts tend to carefully consider, among other things, the economics and so on and so forth, the practicality of doing certain things, looking at do you want to take your people through another situation like this where the election is was too close to call as predicted by the pollsters, and indeed it was the reflection that came through. So it's up to the courts, like we said in the beginning, for them to make that decision. It is nothing. Yes. No, it's happened before. Yes.
No, we have had elections being nullified, but of course not granting. We're not changing the electoral commission the way it is. Are you actually seeing this prayer really realistic? Having election nullified and then having the chairperson of the electoral commission and maybe organize another election under a different leadership?
He's throwing a stone in the bush to see what comes out. To see what comes out. Well, he has a hook that is thrown into the lake, hoping to catch fish.
We actually
because you see, the removal of a chairperson is not simply by a declaration of the courts. You have to prove certain ingredients for that to happen. It's similar to the removal of a judge. Even if you don't like the judge, at least in Uganda, this is a constitutional office. You have to involve the person of the president and so on and so forth. So the court needs to consider.
One judge has been removed
through that process,
and it was under the old constitution, the 1967 constitution. This one is even more rigid.
Yes.
And it's more rigid than the 95 constitution. So it's
So to remove the chairperson will probably be something that has to be really carefully considered. Do you want, because that means really go through the process of removal, then have a new appointment, who swears you in and so on, because you're in a transition period right now, and then have a new election organized.
To wind up this whole discussion, but Edgar, before actually we leave this place, there is a question of precedents and authorities that are used in that case. When you look at actually through the entire document or the petition by Raila, you see his authorities, his own authorities in the previous elections, that's actually served to his advantage in this petition.
I don't know, do you want me to look at it at a practical level or at...
Certainly, both ways.
I'll give you a background that people go to court to enrich in jurisprudence. People go to court to deepen democracy. People go to court to obtain an opinion of an independent arbiter. Him using his precedents, that means he's been a champion in the democratization process. Just like here in Uganda, when you go to court, Kiza Besije, same Ogere. There are those precedents that you can't run away from. So it's...
But even maybe to put it better, these are not his. These are decisions. Decisions of court, and he might have been a party.
Does it actually serve to his, advantage?
No. You see, you don't just cite cases for the sake of it. When you cite a case, regardless of whether you are a party to it or not, you must be able to bring out what principle it is that you are trying to support. So you may cite your own decision or your own case where you are a party, but does it support the argument that you are making? It may not. And remember, at the Supreme Court level, the court is not bound
Even by its own decisions.
Yes. You know, it can easily depart from that decision and say, okay, that was the decision, but the facts here are now different. You know, and we can juxtapose them.
It's the same court.
Yes.
So then everybody's looking at that as going to play to their
In
advantage.
the Maraga instance, I think the discrepancies in the digital process were glaring to be ignored. They were glaring to be ignored. And in this case, well, let's wait for the evidence. I saw a truck. A truckload of boxes. As well as those boxes were full of material. Is another question altogether.
But isn't it also true that the Maraga court had no option upon finding that there were discrepancies and that there were certain things that had gone wrong?
There was doctoring the process.
Because I believe that unlike the law in Uganda, I think at that time with the Maraga decision, and maybe the viewers can guide us, I mean, those who know better, the law did not give the court what the law gives the court in Uganda. Because in Uganda you can find that there were discrepancies, you can find that things didn't go wrong, but then you then go to step 2, which is now the the subjective test by the judges to say, do you think this substantial affected? It seems the Maraga
court go away from the qualitative to quantitative.
So it doesn't happen in Kenya.
No.
I think with Maraga it did not. Maraga didn't have that option.
Maraga just put a spanner in the works and said that the whole thing was what is the word that is not illegitimate. It just didn't comply with their laws, and since there was no compliance, for him he said since there was no compliance, then the legitimacy of the process is
Council, we have actually to wind up this.
But let me just add to this. It's also important to know the process of how Maraga had been appointed, you know, because the judiciary had a lot of independence in choosing who the Chief Justice would be. And so there was, to an extent, not much of an allegiance to the appointing authority. I think that gave them more practical independence. Take that as you
which may not be the case of this.
We have to wind up this, actually, Daniel. Your final word, and what exactly does this actually petition mean to the entire East African community and the entire democratic space?
No, I think it is good to see that instead of going to the bush, instead of taking up arms, that people begin to appreciate. Even before Raila went to court, you could see on social media that people are saying, all right, the decision has been made, now it's time for the lawyers to take over. It's like it was already assumed that a petition is going to happen and that the court will be the final arbiter. I think that kind of consistency is, I think, good for our jurisprudence to know that it is not over yet. Let's go to court in case you are aggrieved. Let court make a decision. And hopefully after that, the matter is settled and wait for the next election cycle.
Edgar, just tell us about this and the way forward, because we understand that this case is now before court and there seem to be actually trust in the court process.
There seems to be
trust.
Let's say there seems to be confidence.
Confidence.
Trust and confidence don't necessarily mean the same thing. There seems to be confidence
in the court
system. Now, I've
said
it before here, I've said it elsewhere, and I'll continue to say it. It's going to be my mantra every time I come to talk on politics, on constitutionalism in this country. What we are seeing in Kenya did not fall from the sky. They've been deliberate, they've been intentional, they've been purposeful. They've been through a checkered history in as far as elections are concerned. And given that background, they made it upon themselves and to posterity that we must change the manner and the way which we do things. and these are the ground rules, how we are going to relate.
Yes.
And everybody seems to be subjecting themselves to those rules and regulations. Now, what is developing there is deepening democracy. And importantly, the culture of adherence to rules rather than whims and individuals. And more importantly, I must add that the culture of constitutionalism is taking effect and it is being nurtured, and that can only happen if persons like yourself, like him, like myself, nurture and sprout those seeds. If you nurture, if you nurture and water the seeds of constitutionalism, you'll reap constitutionalism.
Yes.
If you nurture and sprout seeds of impunity, you will harvest impunity.
Are we seeing a unanimous decision or just...
Well, between me and him, we have the same school of thought. We went to school together. But we have a very rich background.
Yes.
When I was head prefect at Namiago College, he was head prefect at Busoga College, Mwili.
Wow.
We have interacted from the time we were
So
teenagers.
Daniel, are we seeing actually unanimous decision by the court?
By the courts? I'm not too sure.
You're not so
Yeah,
sure?
I think it is too early to tell.
Okay.
You know, if we look at the issues, maybe. It's always good for you to check the...
No, it's going to be a narrow margin.
Yeah.
A narrow
For
margin.
three.
Yeah.
Yeah, I know.
4-3.
Thank you so much, gentlemen, and actually for coming here to, break down some of these issues. When elections, we all have one man, one vote, but when this time comes,
Yes.
it's now actually the battle of the Lego minds. And those who are actually watching us there, even in Kenya, it's an issues now to do with the lawyers to decide which direction actually their country has to take. It also goes back to the people of Kenya and what they want to achieve. It's been actually a discussion to do with the election petition filed in Kenya by the former Prime Minister Raila Odinga, and of course joining us to discuss that has been Dr. Daniel Rugweza, a law doctor at Makerere University, and Counsel Edgar Tabaro, a lawyer at KTA Advocates. It's been a big issue, and of course the rush hour takes a short break. We are returning with a discussion on women and politics in the Rush Talk. Gawe.